Good morning, sir.
Good morning,
What is your name, please?
John Lyle.
Thank you, sir. If you sit tight, court will start shortly.
Thank you.
Good morning, Mr. Goldner.
Good morning. Can you hear me?
I can now. Thank you, sir. This is 211067 GC, Discover Bank versus John Lyle. May I have your appearances, please?
Yes, good morning, Your Honor. Seth Goldner on behalf of the Buckles firm above counsel, representing the plaintiff today, Discover Bank versus Mr. John Lyle.
John Lyle.
Thank you. Today is the day and time set for the adjourned final pretrial in this matter. Mr. Goldner, how are we proceeding this morning?
Well, Your Honor, point of clarification, I show this as a final pretrial as well as a continuation of plaintiff's motion for summary disposition. So I guess first and foremost, my understanding is a motion for summary was filed some time ago, and I think it's been adjourned along with the pretrial. Last time we were in court in November, you allowed a 60 days discovery to investigate the defendant's defenses. I'm prepared to address the motion for summary. I'm prepared to address the pretrial. I just want to make sure we're all on the same page.
This was supposed to be a motion date. The only motion that I saw in the court's file was the motion to reinstate previously from August 17th, where the case was reinstated.
And my apologies, but my problem is I don't have the full file. I was in touch with one of the managing attorneys at the Buckles office yesterday. They referenced the motion. My materials do not include a motion for summary that I can see, but I do believe they must have filed one previously because it's been part of my notes since the beginning. I'm scrolling to see what I can find on that point.
I'm looking at the ROA.
And is the court saying there's never been a motion for summary filed? I'm looking to see what I can find as well, obviously.
I don't see it. There was some conversation about a motion. We were here back on November 16th, because the statement that I made was that the final pretrial and any motion would be today at 9 a.m. There's only one motion fee in this case, and that was back on July 22nd. That was the motion to reinstate after the case was dismissed when the plaintiff's office failed to appear.
I understand. Well, Your Honor, if I may, let me address, I guess, what would essentially be the issue of the pretrial as well as the motion. So we just received, we've engaged in discovery with the defendant, written discovery. He's provided his responses. Those were only just due because the court did afford 60 days for discovery. It was my misimpression or my belief today that the motion had already been filed. Perhaps what's really going on here is now that we have the discovery, we do believe a motion for summary disposition would be appropriate. I would ask the court for an opportunity to file such a motion because, of course, no one wants to go to trial if there's no need for that. This all comes down to, Your Honor, the defense is that essentially unauthorized use of the card or that his information was stolen. Our investigation relative to requesting information from the defendant, I mean, in all fairness, he continues to deny use of the card, but we find some of the known facts to be such that we'd like to bring them to the court's attention in a motion so that perhaps we could decide this on a summary basis. I certainly don't want another pretrial. I would imagine, Your Honor, what I would request if possible would be a motion for summary disposition date followed by a trial date, say a week later or 2 weeks later, to allow us a chance to, if necessary, have a trial. But we certainly want to avoid it, and we only just received, discovery just closed. I guess that's my point.
Mr. Lyle,
Yes.
your response?
I'd rather see this dismissed at this point. It's been It's been a long time. I've been patient. I mean, this is taking an awful long time.
The basis for your request for dismissal?
That I'm a victim of fraud and they hadn't shown any kind of evidence that this was me.
May I reply, Your Honor?
Absolutely.
All right, well, Your Honor, it's plaintiff's burden to prove its case, but it's defendant's burden to prove his defense. We can't prove a negative, and at this point, there's been no formal motion by the defendant, no opportunity to reply. To me, it seems very obvious that an opportunity for both sides to file motions for summary disposition would be appropriate. I know the defendant's not an attorney. Perhaps he perceives this as taking too long, but I mean, what we're trying to do is avoid a trial, because we do at the moment have a very complete disagreement as to what the actual facts are. The police report seems very revealing and does not comport with what Mr. Lyle says. And of course, we just want an opportunity to bring the evidence before the court, short of a trial. Again, it's completely the court's call here, but there's been no delay. All we've been trying to do is diligently figure out whether or not there's anything to support the
Thank you.
defendant's defense at this point.
Mr. Goldner, this case has now been pending since March 3rd, 2021. Mr. Lyle, what this court will do is schedule a final pretrial motion for summary disposition date of February 1st, 2022 at 9:15 a.m. That will be by Zoom with a trial date of February 25th at 9 a.m. The trial date is a live date.
And Your Honor, do you mean by that appearance in court?
Yes. Final pretrial, February 1st, 2022, 9:15 a.m. by Zoom. Trial date in person, February 25th at 9 a.m. in courtroom number 1 with me. This, again, this matter's been pending for almost a year. Mr. Lyle, I have seen the police report as well as the identity theft information that you filed with the FTC. Mr. Goldner, I would suggest that if your client look into that or your office look into that. The court did review the statements that were provided, and I don't see any payments on there. I see charges over a very brief period of time. But Mr. Lyle, you will have to do something more than say it's not me and ask for dismissal. You have to have a legal basis for your request for dismissal. Plaintiff's office has indicated twice now that they'll be filing a motion for summary disposition. If you receive something in the mail, you need to file a written response if you want the court to review it before the hearing on February 1st. Anything else, Mr. Goldner?
On this case, no, Your Honor. I do have another matter before you at 9:30.
Okay, Mr. Lyle, anything else in this matter?
No, are you saying if I receive something from Buckles and Buckles in the mail, I need to respond?
Yes, sir.
Okay, well, I haven't received anything from them.
Understood.
Okay,
We're all set in this matter, Mr. Lyle. See you on Zoom on February 1st, okay?
thank you.
Thank you, sir.
Thank you for your time, Your Honor. I do appreciate it.
Yes, sir. You're 9:30. I give about 15 minutes after, so if your other side's not here by 9:45.
I understand, Your Honor. What I think we have in the other matter is an effort to dismiss the case. We weren't sure if the court had dismissed, so the pending motion is simply to dismiss, and I think that's to the defendant's
Is
benefit.
that TD Bank?
Yes, Your Honor.
No response from the defendant. I'm just waiting for them to appear to figure out why they wouldn't sign the stip that was sent over previously.
Good question. Well, I'll be back in front of you. Well, I'll just be back at 9:30 and we'll do things the normal way, of course.
Thank you, sir.
All right. Thank you, Your Honor. Appreciate it. Oh, permission to leave?
Yes, please.
Okay. Thank you. I left too early once recently by Zoom and I'm a little paranoid. That's all.
No,
You don't
I
want-
understand people need to go dark or check in somewhere else. Not a problem.
Absolutely. I'll be checking back in 15 minutes. Thank you, Ron. Good morning.
Thank you.
Good morning.
Am I in the right place?
I'm sorry.
I'm looking for Judge Lisa Martin.
Yeah, you're in the right place.
Okay,
The judge
You're
will be
here.
out- the judge will be out momentarily.
pardon me.
She said the judge will be taking the bench shortly.
Okay, okay,
You're on with me, so
yes. And I think I recognize you
yeah.
the last time. I think we've got this thing pretty much resolved, don't we?
We just have to get that consent judgment. I'm going to send it out to you and to your to AmeriCorps today. So
Okay,
we'll just ask for an adjournment today, and we should that should resolve everything.
yeah, okay. So,
Okay.
Yep,
Marianne, are you there?
I'm here, yes.
Question for you. I didn't get a notice for this. I just appeared because we had a pretrial back in November on a case here, Thomas versus MB Moving. But I never got a notice for this date. I didn't find it on the docket. I'm just wondering if it's even up today.
If you give me a case number, I will call the civil department and ask them, what's the what's the case number and the case name?
212-783 GC.
Okay,
Sarah Thomas versus MB Moving. I tried to call there yesterday and nobody called me back because I didn't get a notice and I couldn't find it, but just want to make sure.
yeah, I don't see it on my docket for today, but let me call down and, I'll have an answer for you in a second.
Okay. Should I hang on then?
Yep, please, thank you. Mr. Fleming, the civil department said that that's going to Caseyville.
Okay, correct. Yeah, that was the plan. And I hadn't received anything. So they're in the process of doing that.
That's correct.
Okay, so I'll just wait for a notice from you guys then.
Okay, sounds good.
Thank you.
Yeah, you're welcome. Have a good day.
You too.
Thanks.
My apologies, I got pulled into something real quick. This is 211964 GC Citibank versus Terry Shoneth. May I have your appearances, please?
Good morning, Your Honor. Brian Gruen, Groen, P number is 56673 on behalf of plaintiff Citibank.
And this is Terry Shaneth, Your Honor, and I'm ready and raring to go.
Thank you. Today is the day and time set for the final pretrial in this matter. How are we proceeding this morning?
Your Honor, if you recall, the last time we were here, Mr. Shoneth is working with a debt settlement company, AmeriCorps. And since the last hearing, they have touched base with us and the settlement has been reached. So we have actually, I just printed out the proposed consent judgment this morning, and I will be mailing that out to both AmeriCorps and a copy directly to the defendant. And once we receive that back signed, we will get that entered with the court.
So is it sufficient that I put settlement pending, or do you need another date?
Why don't, I always just like to have another date just as a backup.
Well, let me give you a motivator. I will set your trial date January 28th at 9 a.m. in person. That should motivate you to get that signed with AmeriCorps and back here to us.
Well, Your Honor, my only concern is we also had a motion for summary up for today as well. So
Oh,
it was a-
you sure did, sorry. So do you want to just call it a motion date in January? I mean,
Why don't we-
on January 28th, or do you want to do the motion right now?
no, let's do the 28th as a motion date then, and just maybe kick out the trial. I don't, it should not be necessary one way or the other.
Mr. Shoneth, are you following this conversation?
Yes, I am.
Okay,
And I'm going to make sure
make-
that he gets his money, okay?
I'll make a notation in the file that settlement is likely, but we will call it MSD hearing date January 28th at 9. You know what? Let's not do that. Let's not do that. Let's February 1st at 9:30. February 1st at 9:30 by Zoom, the MSD date. No reason to force you here if you are resolved or close to it. And in the meantime, if you're able to get that settlement agreement signed and over to the court, you can submit it electronically to the civil department or mail a hard copy, doesn't matter.
Okay.
Anything else on behalf of plaintiff?
I don't believe so, Your Honor.
No,
Anything else for you, sir?
no. Thank you, Judge.
Thank you so much. I hope not to see you on February 1st, so good luck to you.
I don't want to be there.
Well, look for it the consent judgment in the mail, and just, I'll put an X where you need to sign. Envelope comes with it. Just put it back in the envelope and mail it back to us, and then we won't have to worry about that February 1st date.
All right,
Okay?
okay.
Thank you. You both have a good day.
I will
Thank you,
be
Your
back.
Honor.
I'll be back at 10 a.m., Your Honor.
Thank you, sir.
Thank you.
This is 212119 GC TD Bank USA versus Ronald Rajda.
Good morning, Your Honor. Your Honor.
Good morning again, Mr. Goldner.
Good morning. I'll make my appearance of counsel with Buckles and Buckles for plaintiff TD Bank USA in this matter.
Today is the day and time set for the plaintiff's motion for dismissal.
Yes, Your
Filed
Honor.
back on December 6, 2021. The only reason why the court scheduled it for hearing was out of an abundance of caution that there was some issue that the defendant wanted to address, but it was scheduled for 9:30. It's now 9:42 a.m. by the court's clock. Mr. Goldner, unless there's anything you would add or clarify, this court will sign an order dismissing this case with prejudice.
Your Honor, we appreciate that very much. Thank you. Should I just indicate the order will be mailed out by the court?
Yes, sir. I've already signed it. I'll send it back downstairs.
All right. Well, thank you, Your Honor. I appreciate you taking the time.
Thank you. Have a good
today.
day.
You too. Take care.
Mr. Stidham? Good morning. This is 211803GC Golden Lion versus JT Towing, doing business as Crova Towing. May I have your appearances, please?
Good morning, Your Honor. Greg Zlotopolsky for the plaintiff. I just got a call from brother counsel. Every time he's trying to log in, it kicks him out for the past 10 minutes. Actually, I've seen his name popping up. Your Honor, if I may preempt, I just spoke with him. We're $100 apart. $100. Yes, I know.
So you'll
I
just
will-
split the $50 and, okay, as soon as I see him log back in or try to log back in, let's see if we can get him.
Yeah, what I wanted to say, Judge, maybe we can get a brief adjournment so I can contact my client in California. He's 3 hours behind. So we'll probably resolve it very soon. $100 to $100.
He's coming in right now.
Oh, great.
He was trying to come out of the waiting room and he could not get in. I'm not sure what's going on.
I don't know, Your Honor.
Mr. Johnston?
Good morning.
Good morning, sir. Are you here for Security versus Yoskovitz?
Yes, I am.
I received a consent order this morning that I signed.
Okay, perfect. I just wanted to show up and make sure that the court had received it.
Okay. I saw the case number that scared me. I said, I signed that probably a half hour ago.
Okay, perfect.
Okay.
Thank you, Judge.
Have a good day, sir.
You too.
Your Honor, with due respect, I have brother counsel on the phone right now. He tried 3 different browsers, kicks him out. He's on the speakerphone. Would you like me to do something with it?
He's on speakerphone right now.
Yes, he's on speakerphone right now.
If you're telling me, sir, that you are $100 apart, I believe that the two of you should be able to resolve that. Today is the day and time set for the settlement conference in 211803. I know that your appearance is based on the fact that he had appeared briefly, although he could not speak. The matter is scheduled for trial on February 1st, 2022 at 1 p.m. by Zoom.
Mhm.
And as much as I'd like to see a 1950 Mercury, if you can resolve the $100 difference and can get the settlement documents to me before that trial date.
Okay. Okay. I have no issue. Tom, did you hear that?
No, I did not.
Okay, the judge would like to see 1950 Mercury, but given the fact we're $100 apart, the trial is on the 1st of February, the judge believes we should be able to resolve it.
Right.
Right.
Agreed.
He agreed to, Judge.
Okay, so hopefully I'll see your settlement agreement in the next 2, maybe 3 weeks.
It should not take that long. I will contact my client today, but like I said, California is 3 hours behind.
Understood.
Thank you so much, Your Honor.
Well, Mr. Stidham,
Tom, can you hear it?
No, I didn't hear what she said.
Oh, that's
I just,
because.
does he need anything, from his perspective? Does he
Hold
need
on.
anything on
No
behalf
wonder
of the
he's not here
defendants?
because you were on this. Okay, here we go.
Mr.
Judge,
Stidham?
Yes. Hi, Judge.
Hi, brother counsel indicated that you were about $100 apart. Today is the settlement conference. So my comment to him was, if the two of you can resolve it and get the settlement agreement, whatever it might be, consent judgment or stipulated dismissal, whatever it is, and get it to me in the next couple of weeks, it'd be great. Otherwise, I'll see you here on February 1st, not here in person, but Zoom, February 1st for trial.
Right. Yes, we should be able to do that, Your Honor. I'm confident that we can, and I apologize for some reason, and I'm here at my office. The internet, I've been in the court's waiting room, and they've admitted me, and then it just keeps clicking off. And when I tried
saw
to
you. I saw you come in one time, but I had no video, and then I saw you in our waiting room and I couldn't get you in. But as long as you're fine with us proceeding this way, I'll make a note in the file that there's settlement pending, but I'll leave the trial on until you gentlemen send a document that resolves that issue, okay?
Yes, very well, Your Honor.
Your Honor, and gentlemen,
you. Unless
pertains
any-
I'm sorry, go ahead.
I was gonna say anything on behalf of plaintiff.
Nothing, Your Honor. So when you said gentlemen, that pertains to both of us, right?
Correct.
Thank you so much.
And Your Honor, just so for the court's benefit, my client, Mr. Bokan and Mr. Hussein, we're supposed to be on Zoom. I can't see them right now, but if they are, I'll shoot them a text right now to get off Zoom. But I just wanted the court to know that they were there and they can hang up. So thank you.
Neither of them have been here this morning. If they come on, I'll give them that information, but I haven't seen them today.
Okay. Okay. Thank you.
Okay?
Judge.
Thank you so much, Your Honor.
Appreciate it.
Thank you for
Thank you.
understanding.
Have a good afternoon.
You too, Your Honor.
You too.
Stay safe.
Thank you.
Bye-bye.
So yeah, Marianne, it's a 1950 Mercury.
Wow.
Neither of them have submitted pictures. I got an invoice. I'm curious. I have more questions than answers right now. This is 212907 GC Public Service Credit Union versus Alfonso Reed. Today is the day and time set for the show cause in this matter was scheduled at 9 o'clock. It's now 10:05 by the court's clock. It was the plaintiff's motion for the defendant to be held in civil contempt for failing to surrender the 2015 Chrysler 200 that is the subject of this claim and delivery matter. And as much as neither party has appeared, the motion will be denied at this time. Good morning, Mr. Bokan and Mr. Hussein.
Morning, Judge. How you doing?
Both of the attorneys just left.
All right,
So the matter,
we were having a hard time logging in on the computer, so we had to do it from our cellular phone.
sir, I'm sorry, you're muffled. I can't hear you.
Can you hear me now?
I can, thank you.
Yes. Sorry about that. We had a problem logging in. We had Comcast was down, so we're doing it off the cellular. I do apologize.
What I was saying is both the attorneys were just here. They've indicated that settlement is close. So I'm sure Mr. Stidham will be contacting you to discuss that further. The trial is still on for February 1st, but I don't get the impression that we're going forward.
Yes, ma'am. I believe they're
Okay.
working something out. Thank you.
Anything else for you this morning?
No,
We're fine.
we are fine. Thank you. Thank you, Judge.
Thank you.
Hope
Take
you had a
care.
Have a
marvelous
good
New
day.
Year's.
Good to see you, Mr.
Happy-
Bokan.
Yep,
Take care.
thank
Happy
you.
New Year's. Thank you. Bye-bye.
Bye-bye. Good morning, Ms. Watts. Oh, she's not connected yet. Good morning, ma'am.
Good morning.
How are you today?
I'm good. How are you?
I am wonderful. Your case is not scheduled until 10:30. I have not seen Mr. Collis as of yet. But if you want to sit tight, mute yourself when he gets here. If you need to speak to him, we'll get you into a room with him, okay?
Okay, let me figure out how to mute myself. Okay.
We can do that on our end. It's okay. This is 213511 GC LVMV funding versus Kevin Scott. Have your appearance, please, sir.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673, on behalf of plaintiff LVNV Funding.
Thank you, sir. Today is the day and time set for the first pretrial in this matter. This court did receive an answer from the defendant, Mr. Kevin Scott, wherein he alleges that he's been the victim of identity theft. This matter was scheduled for pretrial this morning at 10 a.m. It's now 10:15 a.m. by the court's clock. The defendant has failed to appear. How do you wish to proceed, sir?
Your Honor, I'll leave that to the discretion of the court. Based on his answer, if he appeared today, I was going to send a fraud affidavit to him to fill out. Based on his allegations, it sounds like that's what appears may be the result of this one. But from the issues from listening in on some other phone calls, it looks like some people have had issues with logging on. So I'm not for sure if the court wants just to maybe adjourn this out for a month and give him one more opportunity. And in the interim, I can mail out that affidavit of fraud along with some credit card statements, and we can just kind of go from there.
I'd appreciate that, sir. We will adjourn the matter out to February 1st, 2022 at 9:45 a.m. That will be back on Zoom, back with me. February 1st at 9:45 a.m. The court will send out notice. I'll make an indication in the file that you appeared and that you'll be sending him statements in the fraud affidavit.
Sounds good, Your Honor.
Anything else in this matter?
I think that should cover it, Your Honor.
Thank you so very much, sir. Is that it for you today?
We had one other questionable one as another LVNV funding that we called on yesterday, and the clerk made it sound like it might still be on your docket. But it looks like we never got service on the defendant, so it really shouldn't be on your docket. So
What's that other LVNV funding?
it was Debbie Smith was the defendant's name.
That was a weird case. I thought
I
that
didn't-
an answer had been filed with the wrong case number.
Is that what it was?
It was, and I thought that they had resolved that. Because what I had was the Heath matter, the LVNV funding versus Heath, but I signed a dismissal in that case yesterday.
Okay, yep, that's
I think those were the two cases that had gotten mixed up previously.
good enough. Okay, that answers my question then as well.
Anything else?
Hopefully that's the last one then, Your Honor.
Thank you, sir.
Thank
Have a good
you.
day.
You too.
Bye-bye. Good morning, Mr. Best.
Good morning, Your Honor.
How are you, sir?
Good, good. Yourself?
I am wonderful, thank you. I have not seen the defendant on the other side from you yet. The case is scheduled at 10:30. I usually take the calls for dismissals at about 15 minutes after the scheduled start time. So if you want to hang around until about 10:45, we'll see if Ms. Pincombe appears.
Sounds good.
Thank you. Mr. Best,
Yes, Your Honor.
Ms. Pincombe is here. Would you like to speak to her in a breakout room, or are you ready to proceed with the pretrial?
I would like to speak with you, Your Honor.
Ms. Pincombe, this is the attorney for the Huntington National Bank. You'll see the invitation to join him in the breakout room. Go there, please, and speak to him. And when you're ready, come out and I'll get the case called and we'll get going, okay?
Okay.
Thank you. This is 213678 GC, the Huntington National Bank versus Rachel Pincombe. May I have your appearances, please?
Thank you. Good morning, Your Honor. Daniel Best, P58501 on behalf of the Huntington National Bank.
Ma'am, would you state your name for me, please?
Rachel Pincombe.
Thank you. Today is the day and time set for the first pretrial in this matter. The parties have had an opportunity to speak. Mr. Best, how are we proceeding this morning?
We do need to proceed with the pretrial. Ms. Pincombe has engaged a debt settlement company who is not in active negotiations with us, and I strongly suggested she contact them to start the negotiations.
So are you looking for a period of discovery, sir?
Yes, Your Honor. I'd ask for 60 days.
60 days discovery will start today and close this March 7th, 2022. We'll schedule the final pretrial in this matter on April 5th, 2022 at 10 a.m. That will be back on Zoom. Any motions must be filed and heard at that final pretrial, that April 5th, 2022 at 10 a.m. And the trial date will be April 29th, 2022. That will be in person. April 29th at 9 a.m. Mr. Best, if you could reduce that to writing and submit that order to the court for entry.
I will do so, Your Honor.
Ms. Pincombe, you might receive some discovery requests from the plaintiff's office. Please respond to those things. Additionally, reach out to the debt settlement company that you referenced in your letter so that they can make contact with the plaintiff's office. And if you're able to resolve the matter short of appearing either on that April 5th final pretrial date or the April 29th trial date, reduce it to writing and we'll get those matters off of our docket, okay?
Okay, thank you so much.
Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else, Ms. Pincombe?
No, thank you.
Thank you. We're all set. Everyone have a good afternoon.
Thank you, you too.
Good morning, Mr. Collis.
Good morning, Judge Martin. How are you?
I'm wonderful, sir. How are you?
You know, it's good to see you in a new year and hoping it's going to be better than the last one.
Ms. Watts is here.
I
This is
see
the
that.
first pretrial in this matter. Do you wish to go into a breakout room with her?
That would be wonderful, Judge.
Ms. Watts, you'll see an invitation to join Mr. Collis in the breakout room. Please join them there. After you've had a chance to speak, come out. I'll get the case called and we'll get you on your way, okay? Two case evaluation. Was that sufficient time in the breakout room?
Yes, it was, Judge.
This is 214650 GC Cherry Hill Venture Limited Partnership versus Courtney Watts. May I have your appearances, please?
For the record, Stuart Collis, P49530, on behalf of the plaintiff.
State your name for me, ma'am.
Oh, I'm sorry, Courtney Watts.
Thank you. Today was the day and time set for the first pretrial in this matter. The parties just came out of the breakout room. Mr. Collis, how are we proceeding this morning?
Your Honor, it's my, even though I don't have a copy of Ms. Watts' answer, it's my understanding that she's not disputing the entire amount. What she's disputing is apparently the October rent, saying that she moved earlier than October. Therefore, Your Honor, I guess we need to do a little bit of discovery. I'll talk to my client regarding Ms. Watts' settlement offer and potentially file a motion for summary.
Any comment, Ms. Watts?
Yeah, I agree. I don't agree with the amount that they were saying. I did not, I moved prior to October, so I don't agree to paying the amount that they requested.
Okay. The court will grant the plaintiff's request for discovery, 60 days discovery, which starts today and closes March 7th, 2022. The parties will come back for final pretrial on April 5th at 10 a.m. That will be
Sorry, what day
on
was that, Judge? I
Zoom.
misheard you.
I'm sorry,
What day was the comeback?
April 5th, 2022. And that will be at 10 a.m. on Zoom. Any motions must be filed and heard by that final pretrial of April the 5th. Trial date will be April 29th at 10 a.m. That trial date is a live date, which means you will come here to the court. 60 days discovery closes March the 7th. Final pretrial, April 5th at 10 a.m. Live trial, April 29th at 10 a.m. Plaintiff's office is submit an order with those dates and deadlines submitted to the court for entry. Copy will be mailed to you, Ms. Watts.
All
Anything
right.
else on behalf of the plaintiff?
Well, since I was counting on those dates being sent out, I want to verify the dates. We have date of discovery for 60 days, next pretrial, April 5th or 15th?
5th,
5th, okay, at 10 a.m. And the trial date is going to be,
April 29th at 10 a.m.
I will get that order drafted and sent out. Do you want that by 7-day order, I assume?
That's fine. Thank you, sir.
All right, anything else I can do for you, Judge or Ms. Watts?
No, so I'll get copies of the stuff in the mail, right?
Correct.
Okay. Thank you.
Thank you very
Anything
much.
else, Mr. Collis? Mr.
sorry?
Collis, anything else?
Oh, no, I said that. Have a great day. I thought you were done with me. Apparently,
Anything
I
else,
don't
Ms.
do it well
Watts?
anymore. You know,
No, that's it. Thank you very much.
Now you're good, Mr. Collis. Have a good day.
Thank you.
Bye-bye.
Good morning, Mr. Rusin.
Hello, Judge Martin. How are you?
I'm wonderful, sir. How have you been?
Oh, always busy. You can see I build bridges.
You're scheduled at 10:45. I have not seen Mr. Russell as of yet. My policy is about 15 minutes.
Well,
So if you want to sit tight for another little bit.
Well, Judge, I would love to, but I want to bring something to the court's attention that I just found 5 minutes ago. When I tried to go on the notice that the court sent to come into Zoom hearing that's on the objection hearing, that's listed as 580-707-8570. It wouldn't let me go in, and I had to go online to the court to find out that the correct Zoom.
Mr. Rusin?
Yeah.
I'm going to stop you because Mr. Russell's here.
Perfect. Perfect.
Mr. Russell?
Yeah, sorry, I have the wrong Zoom ID number.
Our office sent out the wrong number. I appreciate your persistence. Mr. Rusin just brought it to my attention that it was the wrong meeting ID, but you got here, so I appreciate your effort.
Thank you.
This is 210556GC Credit Corp Solutions versus Omar Russell. May I have your appearances, please?
Judge, may I please swear, my name is Attorney Richard Bruson. I'm the attorney of record to the plaintiff. My bar number is 35222. Today, I am the respondent to defendant's objection to an income tax guarantee.
Mr. Russell, state your name for the court, please, sir.
Omar Russell.
Thank you. As Mr. Rusin indicated, today is the day and time for hearing on the defendant's objection to a tax garnishment. Mr. Russell, your objection indicates that you had agreed to a payment plan with the plaintiff, that you signed that consent judgment, but that you were claiming that the writ was not properly issued or is otherwise invalid. Sir, would you like to present your objection to the court?
Yes, I spoke with them before. David, I think his name was at their he worked for the Roslyn, the RVO law, whatever people, and we agreed to a payment plan, and it's actually written. Right here, it's written on the judgment. So we agreed to. It says plaintiff agrees to accept the sum of $95, which is due by the 3rd of March 1921, and after which the plaintiff accept the monthly sum of $104 beginning 4/19 until the sum of $23.83 is received. Once the sum of $23.83 is received, the plaintiff will accept said $23.83 as settlement in full. It says, however, if the defendant defaults on any payments, then the plaintiff may collect the full amount remaining due on the judgment without regard of the $23.83. And I have all my bank statements, I have all my receipts, and I have not defaulted. So I was kind of confused on getting this garnishment when we already agreed to me paying the monthly $104. And I've been doing that for the last 8 months, so.
Mr. Rusin.
Judge, let me perfect the record. Let me first say that it is true that what Mr. Russell has stated with him being current on his monthly installment payments is correct. The court and Mr. Russell will notice that on the portion of the judgment that Mr. Russell is referring to, where that installment payment language is printed, it's what the court will know as in the conditions portion of the judgment. And the court should take judicial notice that in that portion of the conditions, in the pre-printed portions, it says that plaintiff shall not issue a periodic garnishment as long as payment is made. Now I'll be speaking as a lawyer for the next 90 seconds, and it's this. Pursuant to court rule MCR 3.101 M, N as in Nancy, it states that if you have an installment payment that doesn't bar the plaintiff from filing an income tax garnishment, which is what happened here. But Mr. Russell and the court should note that my office did not file a periodic garnishment, and it will not file a periodic garnishment under law because of the installment payment that we agreed to that's right on the judgment. So I will also close my response by saying to Mr. Russell that even though he is current on his installment payment, and even though it may happen that once he files his state income tax paperwork, and he's entitled to a refund, if that income tax garnishment refund from the state is diverted to me, the magic number, if I can call it that, speaks for itself. Once Mr. Russell pays $2,383, even by the installment payment, even by the tax garnishment, I stop. He's now paid what he agreed to, voluntary or involuntary, and then it would be incumbent upon me to take the lower amount, assuming that he's maintaining his monthly payment. So that being said, pursuant to MCR 3.101N, I rest and I ask that the objection be denied today.
Mr. Russell, any response?
Yes, however, I'm not a lawyer. So I mean, yeah, there's like little things, like you said, 3 point whatever. I'm not, you can still move forward with the garnishment, but I was led to believe during the conversation that this was what it was. That I wasn't led to believe. No one mentioned anything about a garnishment possibly happening. You know, my refund check, I have to use it for certain things. We agreed to $104 a month. It wasn't $104 a month, and you agreed to your check being garnished at the end of the year. Like, we agreed to a payment plan, and this is, I feel like, what we should stick by. It shouldn't be anything on top of that. The $23.83, I'm gonna pay it off $104 a month. I may pay it off sooner than that, but the money I'm getting at the end of the year, I have to use for certain things, and that's not what I agreed upon, basically. So I object to the garnishment.
Mr. Russell, the court understands your objection, and the court rule cited by Mr. Rusin is Michigan Court Rule 3.101 paragraph N that specifically provides that installment payment plan will only protect you from garnishment as to your wages. It does not stop a plaintiff or a creditor's attorney from filing a garnishment as to your bank account or to your income tax refund or any refund that you might have due coming from the state of Michigan. Some attorneys put language in their consent judgment that says they will not do these other things so long as you're current on your payment. But this court did review the consent judgment that was signed back on March 30th, 2021. And there is no comment in the conditions of that judgment that prohibit plaintiff's office from filing an income tax garnishment. For that reason, and the court rule cited by Mr. Rusin, the court has to deny your objection, find them invalid, and deny them in their entirety. Any refund that you have coming from the state of Michigan is subject to that garnishment you've now received a copy of.
Okay, can I ask a question?
Yes,
So the judge, the paper that I received says $3,092.25. How do I
know?
know?
Your paper so we can look at the same thing at the same time.
Yeah.
Are you talking about the judgment, sir?
Yeah. The judgment. It was the judgment that I got basically about the garnishment. It says, I'm talking about the request for writ for garnishment paper. It says $3,092.25 at the top. So based on this paper, that's what I owe. That's what you're saying I have to pay, or whoever's saying I have to pay. How do I know that it will stop at the $23.83? He just said it, but it's not written anywhere. So really they can take what they want.
Sir, it is written. The judgment that you signed previously, that Mr. Rusin signed, and that I signed on March the 30th indicates that although $3,092.25 is due, that if you pay this $2,383, that will basically settle the case. It'll be that lesser amount. So what I would suggest to you is that in addition to any proofs of payments you have for the payments you've made so far, the $95 payment and then the subsequent $104 payments, I would suggest you keep proof of that. If there is a refund that's due to you from the state, you'll receive a notice of how much that money is as well. So if you have receipts that show that plaintiff has received $2,383, that should be the end of it. If you find that they have received more than that, I would suggest that you then file another request with the court to review the matter. But for right now, even if you've made every payment that's come due, you've paid just over $1,000.
I pay more than the minimum. So, yeah.
Mr. Russell, I'm just saying, based on my math from the payments that were due, I was showing that you should have paid about $1,031 or so.
Yeah, I paid a little more than that, but yeah, I paid over that, yeah.
So
Correct.
I'm just saying, suggesting that you keep track of your payments, and if you get to the amount that you agreed to with the plaintiff's office and they continue to try to take money, that's something we can discuss at a future date. But for right now, the only thing before the court is your objection to the tax garnishment. And because it was not specifically addressed in the garnishment, the court has to rely on the court rules that say that installment payment order only protects your wages. It does not protect and does not protect your other assets, and does not stop the plaintiff from filing income tax garnishments.
Okay.
Anything else, Mr. Russell?
This is all written on the website? Because what protects like the regular citizen who doesn't, know these exact, details to prepare themselves?
It is, there are legal resources available. There's legal aid available to people. There's Michigan legal help. People find ways to kind of explore and research things before they come to court for the first time. And some attorneys offer it in terms of settlement. They say, so long as you make these payments, we won't do any other collections. But that's a case-by-case basis.
Judge, just two things to be helpful with for Mr. Russell, Richard Rusin for the plaintiff. Two things. I'm showing at the moment that I have received in hand from Mr. Russell on this consent judgment, $1,390. And I want to just close by saying to Mr. Russell that there is what is called the Western Wayne County Bar Association. He can look them up online, call them, and I'm sure if he needs to talk to a lawyer, many bar associations I belong to have a free service where you can talk to a lawyer on the first visit for free. And if that's available to him, that's available to him.
I think that's Mr. Rusin's way of closing this out. Mr. Russell, do you have anything else for the court this morning?
No.
Anything else, Mr. Rusin?
I rest.
Thank you. Good luck to you, Mr. Russell. We're all set in this matter. Have a good day.
Thank you.
This is 171466 GC, Volunteers of America versus Karen Maddox and Nictor LLC. This matter was scheduled for entry of order at 10:45 a.m. It's 11:03 a.m. by the court's clock. None of the parties have appeared. This was plaintiff's request for entry of default judgment against garnishee defendant Nictor, Niktor LLC at 28 Main Street, Farmington, Connecticut, 06032. The court asked that this matter be scheduled to ensure that plaintiff served the garnishee defendant with the notice of the failure to disclose that now appears in the file. That plaintiff served the garnishee defendant with the notice of failure to disclose on September 27, 2021. Although the party has failed to appear, the requested proofs are now in the court's file. And the default requested against garnishee defendant will be signed. Mary Ann, that's all I have until noon. Thank you, ma'am.
Okay. I think, are you just gonna leave it up or are you taking it down? What are you gonna do?
I'll leave Zoom up. I'm gonna take us off of